The Philippine Constitution. Constitution. Definition, nature, and concepts. Amendments and revisions. Q. State the various modes of and steps in revising or amending the Philippine Constitution. A. There are 3 modes of amending the Constitution. Under Section 1, Article 28 of the Constitution, Congress may by 3/4 vote of all of its members propose any amendment to or revision of the Constitution. Under the same provision, a constitutional convention may propose any amendment to or revision of the Constitution. According to Section 3, Article 27 of the Constitution, Congress may, by a 2/3 vote of all its members, call a constitutional convention, or by a majority vote of all of its members, submit the question of calling such a convention to the electorate. Under Section 2, Article 27 of the Constitution, the people may directly propose amendments to the Constitution through initiative upon a petition of at least 12% of the total number of registered voters, of which every legislative district must be represented by at least 3% of the registered voters therein. According to Section 4, Article 27 of the Constitution, to be valid, any amendment to or revision of the Constitution must be ratified by a majority of the votes cast in the plebiscite. Q. An amendment to or revision of the present Constitution may be proposed by a constitutional convention or by the Congress upon a vote of 3/4 of all its members. Is there a third way of proposing revisions of or amendments to the Constitution? If so, how? A. There is no third way of proposing revisions to the Constitution. However, the people, through initiative, upon petition of at least 12% of the total number of registered voters, of which every legislative district must be represented by at least 3% of the registered voters in it, may directly propose amendments to the Constitution. This right is not operative without any implementing law. General considerations. National territory. Q. William, a private American citizen, a university graduate, and frequent visitor to the Philippines, was inside the U.S. Embassy when he got into a heated argument with a private Filipino citizen. Then, in front of many shocked witnesses, he killed the person he was arguing with. The police came and brought him to the nearest police station. Upon reaching the station, the police investigator, in halting English, informed William of his Miranda rights and assigned him an independent local counsel. William refused the services of the lawyer and insisted that he be assisted by a Filipino lawyer currently based in the U.S. The request was denied, and the counsel assigned by the police stayed for the duration of the investigation. William protested his arrest. He argued that since the incident took place inside the U.S. Embassy, Philippine courts have no jurisdiction because the U.S. Embassy grounds are not part of Philippine territory. Thus, technically, no crime under Philippine law was committed. Is William correct? Explain your answer. William is not correct. The premises occupied by the United States Embassy do not constitute territory of the United States, but of the Philippines. Crimes committed within them are subject to the territorial jurisdiction of the Philippines. Since William has no diplomatic immunity, the Philippines can prosecute him if it acquires custody over him. Archipelagic Doctrine. Q. What do you understand by the Archipelagic Doctrine? Is this reflected in the 1987 Constitution? The Archipelagic Doctrine emphasizes the unity of land and waters by defining an archipelago either as a group of islands surrounded by waters or a body of waters studded with islands. For this purpose, it requires that baselines be drawn by connecting the appropriate points of the outermost islands to encircle the islands within the archipelago. The waters on the landward side of the baselines, regardless of breadth or dimensions, are merely internal waters. Yes, the Archipelagic Doctrine is reflected in the 1987 Constitution. Article 1, Section 1 provides that the national territory of the Philippines includes the Philippine Archipelago, with all the islands and waters embraced therein, and the waters around, between, and connecting the islands of the archipelago, regardless of their breadth and dimensions, form part of the internal waters of the Philippines. Q. True or false? Explain your answer in not more than 2 sentences. Under the archipelago doctrine, the waters around, between, and connecting the islands and the archipelago form part of the territorial sea of the archipelagic state. False. Under Article 1 of the Constitution, the water around, between, and connecting the islands of the Philippines form part of its internal waters. Under Article 49 of the UN Convention on the Law of the Sea, these waters do not form part of the territorial sea, but are described as archipelagic waters. What is the basis of the Philippines' claim to a part of the Spratly Islands? The basis of the Philippine claim is effective occupation of a territory not subject to the sovereignty of another state. The Japanese forces occupied the Spratly Island group during the Second World War. However, under the San Francisco Peace Treaty of 1951, Japan formally renounced all right and claim to the Spratlys. The San Francisco Treaty, or any other international agreement, however, did not designate any beneficiary state following the Japanese renunciation of right. Subsequently, the Spratlys became terra nullius and was occupied by the Philippines in the title of sovereignty. Philippine sovereignty was displayed by open and public occupation of a number of islands, by stationing of military forces, by organizing a local government unit, and by awarding petroleum drilling rights, among other political and administrative acts. In 1978, it confirmed its sovereign title by the promulgation of Presidential Decree No. 1596, which declared the Calayan Island Group part of the Philippine territory. Q. Congress passed Republic Act No. 7711 to comply with the United Nations Convention on the Law of the Sea. In a petition filed by the Supreme Court, Anak T. Ilocos, an association of Ilocano professionals, argued that Republic Act No. 7711 disregarded the definition of the Philippine territory under the Treaty of Paris and in related treaties, excluded the Calayan Islands and the Scarborough Shoals from the Philippine archipelagic baselines, and converted internal waters into archipelagic waters. Is the petition meritorious? No, the petition is not meritorious. The United Nations Convention on the Law of the Sea has nothing to do with the acquisition or loss of territory. It merely regulates sea use rights over maritime zones, contiguous zones, exclusive economic zones, and continental shelves which it delimits. The Calayan Islands and the Scarborough Shoals are located at an appreciable distance from the nearest shoreline of the Philippine archipelago. A straight baseline loped around them from the nearest baseline will violate Article 47.3 and Article 47.2 of the United Nations Convention on the Law of the Sea 3. Whether the bodies of water lying landward of the baselines of the Philippines are internal waters or archipelagic waters, the Philippines retains jurisdiction over them. Q. A bill was introduced in the House of Representatives in order to implement faithfully the provisions of the United Nations Convention on the Law of the Sea, UNCLOS, to which the Philippines is a signatory. Congressman Pat Rio Tech questioned the constitutionality of the bill on the ground that the provisions of UNCLOS are violative of the provisions of the Constitution defining the Philippine internal waters and territorial sea. Do you agree or not with the said objection? Explain. I do not agree. Whether referred to as Philippine internal waters under the Constitution or as archipelagic waters under the UNCLOS 3, the Philippines exercises sovereignty over the body of water lying landward of the baselines, including the airspace over it and the submarine areas underneath, as affirmed by the provisions of the UNCLOS 3. The fact of sovereignty, however, does not preclude the operation of municipal and international law with respect to the principle of freedom of navigation, and thus the Philippine government may pass legislation in order to regulate the right to innocent and sea lanes passage. QA. Define the archipelagic doctrine of national territory. State its rationale and explain how it is implemented through the straight baseline method. QB. Section 2 of RA 9522 declared the Calayan Island Group, KIG, and Scarborough Shoal as regime of islands. Professor Agaton contends that since the law did not enclose said islands, the Philippines lost its sovereignty and jurisdiction over them. Is this correct? Explain. A. By the term archipelagic doctrine of national territory, it is meant that the islands and waters of the Philippine archipelago are united in sovereignty, together with all the territories over which the Philippines has sovereignty or jurisdiction. This archipelagic doctrine, so described under Article 1 of the Constitution, draws its rationale from the status of the whole archipelago in sovereignty by which under Part 5 of the UNCLOS the Philippines is defined as an archipelagic state in Article 46. Thus, A. Archipelagic state means a state constituted wholly by one or more archipelagos and may include other islands. B. Archipelago means a group of islands including parts of islands, interconnecting waters, and other natural features which are so closely interrelated that such islands, waters, and other natural features form an intrinsic geographic, economic, and political entity, or which historically have been regarded as such. As an archipelagic state, the national territory is implemented by drawing its straight archipelagic baselines pursuant to Article 47 of the UNCLOS, which prescribes among its main elements as follows. 1. By joining the outermost points of the outermost islands and drying reefs of the archipelago, including the main islands, and an area in which the ratio of the area of the water to the land, including atolls, is between 1:1 and 9:1. 2. Mainly, the length of such baselines shall not exceed 100 nautical miles. 3. The drawing of such baselines shall not depart to any appreciable extent from the general configuration of the archipelago. B. The contention of Professor Agaton is not correct at all. Regime of islands is a concept provided in Article 121 of the UNCLOS. It is a definition of the island as a naturally formed area of land surrounded by water, which is above water at high tide. On the other hand, this provision is differentiated from rocks, which cannot sustain human habitation of their own. The importance of the difference between natural island and rock is that an island is provided with territorial sea, exclusive economic zone, and continental shelf, whereas rocks have no exclusive economic zone and continental shelf. This is the difference by which RA 9522 introduced into the KIG, and separately Panatag or Scarborough Shoal is an island. Regime of islands has no relevance to acquisition or loss of sovereignty. RA 9522 has the effect of possibly dividing the area in question into island and rocks, apparently to make clear for each of the maritime zones involved in the definition of island or of rocks. State immunity. Q. It is said that waiver of immunity by the state does not mean a concession of its liability. What are the implications of this phrase? A. The phrase that waiver of immunity by the state does not mean a concession of liability means that by consenting to be sued, the state does not necessarily admit it is liable. As stated in Philippine Rock Industries, Inc. v. Board of Liquidators 180, SCRA 171. In such a case, that state is merely giving the plaintiff a chance to prove that the state is liable, but the state retains the right to raise all lawful defenses. QA. What do you understand by state immunity from suit? Explain. QB. How may consent of the state to be sued be given? Explain. A. State immunity from suit means that the state cannot be sued without its consent. A corollary of such principle is that properties used by the state in the performance of its governmental functions cannot be subject to judicial execution. B. Consent of the state to be sued may be made expressly as in the case of a specific, express provision of law, as waiver of state immunity from suit is not inferred lightly, or implied as when the state engages in proprietary functions, or when it files a suit, in which case the adverse party may file a counterclaim, or when the doctrine would, in effect, be used to perpetuate an injustice. Q. The employees of the Philippine Tobacco Administration, PTA, sued to recover overtime pay. In resisting such claim, the PTA theorized that it is performing governmental functions. Decide and explain. A. As held in Philippine Virginia Tobacco Administration v. Court of Industrial Relations, 65 SCRA 416, the Philippine Tobacco Administration is not liable for overtime pay, since it is performing governmental functions. Among its purposes are to promote the effective merchandising of tobacco, so that those engaged in the tobacco industry will have economic security, to stabilize the price of tobacco, and to improve the living and economic conditions of those engaged in the tobacco industry. Q. The Republic of the Philippines, through the Department of Public Works and Highways, DPWH, constructed a new highway linking Metro Manila and Quezon Province, and which major thoroughfare traversed the land owned by Mang Pandoy. The government neither filed any expropriation proceedings nor paid any compensation to Mang Pandoy for the land thus taken and used as a public road. Mang Pandoy filed a suit against the government to compel payment for the value of his land. The DPWH filed a motion to dismiss the case on the ground that the state is immune from suit. Mang Pandoy filed an opposition. Resolve the motion. The motion to dismiss should be denied. As held in Amigable v. Cuenca, 43 SCRA 300, 1972, when the government expropriates private property without paying compensation, it is deemed to have waived its immunity from suit. Otherwise, the constitutional guarantee that private property shall not be taken for public use without payment or of just compensation will be rendered nugatory. Question. MBC, an alien businessman dealing in carpets and caviar, filed a suit against policeman and YZ, an attaché of XX embassy, for damages because of malicious prosecution. MBC alleged that YZ concocted false and malicious charges that he was engaged in drug trafficking, whereupon narcotics policemen conducted a buy-bust operation, and without warrant arrested him, searched his house, and seized his money and jewelry, then detained and tortured him in violation of his civil and human rights, as well as causing him, his family, and business serious damages amounting to 2 million pesos. MBC added that the trial court acquitted him of the drug charges. Assailing the court's jurisdiction, YZ now moves to dismiss the complaint on the ground that 1. He is an embassy officer entitled to diplomatic immunity, and that 2. The suit is really a suit against his home state without its consent. He presents diplomatic notes from XX Embassy, certifying that he is an accredited embassy officer recognized by the Philippine government. He performs official duties, he says, on a mission to conduct surveillance of drug experts and then inform local police officers who make the actual arrests of suspects. Are the 2 grounds cited by YZ to dismiss the suit tenable? The claim of diplomatic immunity of YZ is not tenable, because he does not possess an acknowledged diplomatic title and is not performing duties of a diplomatic nature. However, the suit against him is a suit against XX without its consent. YZ was acting as an agent of XX and was performing his official functions when he conducted surveillance on drug exporters and informed the local police officers who arrested MBC. He was performing such duties with the consent of the Philippine government. Therefore, the suit against YZ is a suit against XX without its consent. Q. Adams and Baker are American citizens residing in the Philippines. Adams befriended Baker and became a frequent visitor at his house. One day, Adams arrived with 30 members of the Philippine National Police, armed with a search warrant authorizing the search of Baker's house and its premises for dangerous drugs being trafficked to the United States of America. The search purportedly yielded positive results, and Baker was charged with violation of the Dangerous Drugs Act. Adams was the prosecution's principal witness. However, for failure to prove his guilt beyond reasonable doubt, Baker was acquitted. Baker then sued Adams for damages for filing trumped-up charges against him. among the defenses raised by Adams is that he has diplomatic immunity conformably with the Vienna Convention on Diplomatic Relations. He presented diplomatic notes from the American Embassy stating that he is an agent of the United States Drug Enforcement Agency tasked with conducting surveillance operations on suspected drug dealers in the Philippines, believed to be the source of prohibited drugs being shipped to the U.S. It was also stated that after having ascertained the target, Adams would then inform the Philippine narcotic agents to make the actual arrest. As a counsel of Plaintiff Baker, argue why his complaint should not be dismissed on the ground of Defendant Adams' diplomatic immunity from suit. As counsel of Defendant Adams, argue for the dismissal of the complaint. As counsel of Baker, I shall argue that Baker has no diplomatic immunity because he is not performing diplomatic functions. Alternative answer. As counsel for Baker, I will argue that Adams' diplomatic immunity cannot be accepted as the sole basis for dismissal of the damage suit by mere presentation of diplomatic notes stating that he is an agent of the U.S. Drug Enforcement Agency. His diplomatic status was a matter of serious doubt on account of his failure to disclose it when he appeared as principal witness in the earlier criminal drug case against Baker. Considering that as a matter of diplomatic practice, a diplomatic agent may be allowed or authorized to give evidence as a witness by the sending state. Thus, his diplomatic status was not sufficiently established. B. As counsel of Adams, I shall argue that since he was acting within his assigned functions with the consent of the Philippines, the suit against him is a suit against the United States without its consent and is barred by state immunity from suit. Q. Italy, through its ambassador, entered into a contract with Abad for the maintenance and repair of specified equipment at its embassy and ambassador's residence, such as air conditioning units, generator sets, electrical facilities, water heaters, and water motor pumps. It was stipulated that the agreement shall be effective for a period of 4 years and automatically renewed unless cancelled. Further, it provided that any suit arising from the contract shall be filed with the proper courts in the city of Manila. Claiming that the maintenance contract was unilaterally, baseless, and arbitrarily terminated, Abad sued the state of Italy and its ambassador before a court of the city of Manila. Among the defenses they raised were sovereign immunity and diplomatic immunity. As counsel of Abad, refute the defenses of sovereign immunity and diplomatic immunity raised by the state of Italy and its ambassador. At any rate, what should be the court's ruling on the said defenses? A. As counsel of Abad, I shall argue that the contract is not a sovereign function and that the stipulation that any suit arising under the contract shall be filed with the proper courts of the city of Manila is a waiver of the sovereign immunity from suit of Italy. I shall also argue that the ambassador does not enjoy diplomatic immunity because the suit relates to a commercial activity. The court should reject the defenses. Since the establishment of a diplomatic mission requires the maintenance and upkeep of the embassy and the residence of the ambassador, Italy was acting in pursuit of a sovereign activity when it entered into the contract. The provision in the contract regarding the venue of lawsuits is not necessarily a waiver of sovereign immunity from the suit. It should be interpreted to apply only where Italy elects to sue in the Philippine courts or waives its immunity by a subsequent act. The contract does not involve a commercial activity of the ambassador because it is connected with his official functions. The ambassador of the Republic of Kafiristan referred to you for handling the case of the embassy's maintenance agreement with CBM, a private domestic company engaged in maintenance work. The agreement binds CBM for a defined fee to maintain the embassy's elevators, air conditioning units, and electrical facilities. Section 10 of the agreement provides that the agreement shall be governed by Philippine laws and that any legal action shall be brought before the proper court of Makati. Kafiristan terminated the agreement because CBM allegedly did not comply with their agreed maintenance standards. CBM contested the termination and filed a complaint against Kafiristan, before the Regional Trial Court of Makati. The ambassador wants you to file a motion to dismiss the ground of state immunity from suit and to oppose the position that under Section 10 of the agreement, Kafiristan expressly waives its immunity from suit. Under these facts, can the embassy successfully invoke immunity from suit? A. Yes, the embassy can evoke immunity from suit. Section 10 of the Maintenance Agreement is not necessarily a waiver of sovereign immunity from suit. It was meant to apply in case the Republic of Kafiristan elects to sue in the local courts or waives its immunity by a subsequent act. The establishment of a diplomatic mission is a sovereign function. This encompasses its maintenance and upkeep. The maintenance agreement was in pursuit of a sovereign activity. In the last quarter of 2012, about 5,000 container vans of imported goods intended for the Christmas season were seized by agents of the Bureau of Customs. The imported goods were released only on January 10, 2013. A group of importers got together and filed an action for damages before the Regional Trial Court of Manila against the Department of Finance and Bureau of Customs. The Bureau of Customs raised the defense of immunity from suit, and alternatively, that liability should lie with XYZ Corp., which the Bureau had contracted for the lease of 10 high-powered van cranes, but delivered only 5 of these cranes, thus causing the delay in its cargo handling operations. It appears that the Bureau, despite demand, did not pay XYZ Corp. the 1 million peso deposit, an advance rental required under their contract. A. Will the action by the group of importers prosper? A. No, the action by the group of importers will not prosper. The primary function of the Bureau of Customs is governmental, that of assessing and collecting lawful revenues from imported articles and all other tariff and custom duties, fees, charges, fines, and penalties. B. Can XYZ Corp. sue the Bureau of Customs to collect rentals for the delivered cranes? A. No. XYZ Corporation cannot sue the Bureau of Customs to collect rentals for the delivered cranes. The contract was a necessary incident to the performance of its governmental function. To properly collect the revenues and customs duties, the Bureau of Customs must check to determine if the declaration of the importers tallies with the landed merchandise. The cranes are needed to haul the landed merchandise to a suitable place for inspection. Alternative answer: no. XYZ Corporation cannot sue the Bureau of Customs because it has no juridical personality separate from that of the Republic of the Philippines. Another alternative answer: yes. XYZ Corporation may sue the Bureau of Customs because the contract is connected with a proprietary function, the operation of the arrastre service. Besides, XYZ Corporation leased its van cranes. Because the Bureau of Customs undertook to pay its rentals, justice and equity demand that the Bureau of Customs should not be allowed to invoke state immunity from suit. General Principles and State Policies. Q. The Philippines has become a member of the World Trade Organization, WTO, and resultantly agreed that it shall ensure the conformity of its laws, regulations, and administrative procedures with its obligations as provided in the annexed agreements. This is assailed as unconstitutional because this undertaking unduly limits, restricts, and impairs Philippine sovereignty and means, among others, that Congress could not pass legislation that will be good for our national interests and general welfare if such legislation will not conform with the WTO agreements. Refute this argument. A. According to Tanara v. Angara, the sovereignty of the Philippines is subject to restriction by its membership in the family of nations and the limitations imposed of treaty limitations. Section 2, Article 2 of the Constitution adopts the generally accepted principles of international law as part of the law of the land. One of such principles is pacta sunt servanda. The Constitution did not envision a hermit-like isolation of the country from the rest of the world. Q. Under the executive agreement entered into between the Philippines and other members of the SAEAN, the other members will each send a battalion-sized unit of their respective armed forces to conduct a combined military exercise in the Subic Bay area. A group of concerned citizens sought to enjoin the entry of foreign troops as violative of the 1987 Constitution that prohibited the stationing of foreign troops and the use by them of local facilities. As the judge, decide the case. Explain. A. I will rule in favor of the concerned citizens. Section 25, Article 27 of the Constitution prohibits in the absence of a treaty the stationing of troops and facilities of foreign countries in the Philippines. The Supreme Court has already ruled that the provision in Article 28, Section 25 of the Constitution requires a treaty even for the mere temporary presence of foreign troops in the Philippines. Q. The Philippines and the Republic of Croatia established diplomatic relations, and immediately their respective presidents signed the following. 1. Executive agreement allowing the Republic of Croatia to establish its embassy and consular offices within Metro Manila, and 2. Executive agreement allowing the Republic of Croatia to bring to the Philippines its military complement, warships, and armaments from time to time for a period not exceeding 1 month for the purpose of training exercises with the Philippine military forces, and exempting from Philippine criminal jurisdiction acts committed in the line of duty by foreign military personnel, and from paying custom duties on all the goods bought by said foreign forces into Philippine territory in connection with the holding of the activities authorized under the said executive agreement. Senator Magap questioned the constitutionality of the said executive agreements and demanded that the executive agreements be submitted to the Senate for ratification, pursuant to the Philippine Constitution. Is Senator Magap correct? Explain. A. Senator Magap is partly correct. The executive agreement allowing the Republic of Croatia to establish its embassy and consular offices within Metro Manila is valid without the need of submitting it to the Senate for ratification, as differed from a treaty. However, the second executive agreement, which allows the Republic of Croatia to bring to the Philippines its military complement, warships, and armaments for a certain period, is subject to the provisions of Section 25 of Article 28 of the Constitution, which provides that foreign bases, troops, or facilities shall not be allowed in the Philippines except under a treaty duly concurred in by the Senate, and when the Congress so requires, ratified by a majority of the votes cast by the people in a national referendum held for that purpose, and recognized as a treaty by the people of the contracting state. Under the same provision, a treaty duly concurred in by the Senate is required even for the temporary presence of foreign troops. Separation of powers. Q. The Poverty Alleviation and Assistance Act was passed to enhance the capacity of the most marginalized families nationwide. A financial assistance scheme called Conditional Cash Transfers was initially funded 500 million pesos by Congress. One of the provisions of the law gave the Joint Congressional Oversight Committee authority to screen the list of beneficiary families initially determined by the Secretary of Department of Social Welfare and Development pursuant to the development of implementing rules. Mang Pandoy, a resident of Smoky Mountain in Tondo, questioned the authority of the committee. Is the grant of authority to the Oversight Committee to screen beneficiaries constitutional? A. The grant of authority to the Oversight Committee to screen beneficiaries is unconstitutional. It violates the principle of separation of powers. By being involved in the implementation of the law, the Oversight Committee will be exercising executive power. Q. Senator Fleur de Lis is charged with plunder before the Sandigan Baya. After finding the existence of probable cause, the court issues a warrant for the senator's arrest. The prosecution files for a motion to suspend the senator relying on Section 5 of the Plunder Law. According to the prosecution, the suspension should last until the termination of the case. Senator Lee vigorously opposes the motion, contending that only the Senate can discipline its members, and that to allow his suspension by the court would violate the principle of separation of powers. Is Senator Lee's contention tenable? Explain. The contention of the senator is not tenable. The power of each House of Congress to punish its members for disorderly behavior, or suspend or expel a member by a vote of 2/3 of all its members, subject to the qualification that the penalty of suspension, when imposed, should not exceed 60 days, under Section 6(3), Article 6 of the Constitution is distinct from the suspension under the plunder law, which is not a penalty but a preliminary, preventative measure, prescinding from the fact that the latter is not being imposed on petitioner for misbehavior as a member of the House of Representatives. The doctrine of separation of powers cannot be deemed to have excluded members of Congress from the application of the plunder law. The law itself does not exclude members of Congress from its coverage. The Sandiganbayan did not err in issuing the preventative suspension order. Delegation of powers. Q. Suppose that Congress passed a law creating a Department of Human Habitat and authorizing the Department of Secretary to promulgate implementing rules and regulations. Suppose further that the law declared that violation of the implementing rules and regulations so issued would be punishable as a crime and authorize the Department Secretary to prescribe the penalty for such violation. If the law defines certain acts as violations of the law and makes them punishable, for example, with imprisonment of 3 years or a fine in the amount of 10,000 pesos, or both, such imprisonment and fine, in the discretion of the court, can it be provided in the implementing rules and regulations promulgated by the Department Secretary that their violation will also be subject to the same penalties as those provided in the law itself? Explain your answer fully. A. The rules and regulations promulgated by the Secretary of Human Habitat cannot provide that the penalties for their violation will be the same as the penalties for the violation of the law. As held in the United States v. Barrias, 11 Phil 327, the fixing of the penalty for criminal offenses involves the exercise of legislative power and cannot be delegated. The law itself must prescribe the penalty. Q. Section 32 of Republic Act No. 4670, the Magna Carta for Public School Teachers, reads, Section 32, Penal Provision. A person who shall willfully intervene with, restrain or coerce any teacher in the exercise of his rights guaranteed by this act, or who shall in any other manner commit any act to defeat any of the provisions of this act, shall, upon conviction, be punished by a fine of not less than 100 pesos, nor more than 1,000 pesos, or by imprisonment, in the discretion of the court. Is the proviso granting the court the authority to impose a penalty or imprisonment in its discretion constitutional? Explain briefly. The proviso is unconstitutional. Section 32 of R.A. No. 4670 provides for an indeterminable period of imprisonment, with neither a minimum nor a maximum duration having been set by the legislative authority. The courts are thus given wide latitude of discretion to fix the term of imprisonment without even the benefit of any sufficient standard, such that the duration thereof may range, in the words of respondent judge, from 1 minute to the lifespan of the accused. This cannot be allowed. It vests in the courts a power and a duty essentially legislative in nature, and which, as applied to this case, does violence to the rules on separation of powers, as well as the non-delegability of legislative powers. Q. The two accepted tests to determine whether or not there is a valid delegation of legislative power are the Completeness test and the Sufficient Standard test. Explain each. A. Under the Completeness test, a law must be complete in all its terms and provisions when it leaves the legislator, that nothing is left to the judgment of the delegate. The legislature does not abdicate its function when it describes what job must be done, who is to do it, and what is the scope of his authority. However, a delegation of power to make the laws which necessarily involves a discretion as to what it shall be may not constitutionally be done. Under the sufficiency of standards test, the statute must not only define a fundamental legislative policy, mark its limits and boundaries, and specify the public agency to exercise the legislative power. It must also indicate the circumstances under which the legislative command is to be effected. To avoid the taint of unlawful delegation, there must be a standard, which implies at the very least that the legislator itself determines matters of principle and lays down fundamental policy. Legislative Department. Who may exercise legislative power? Q. Are the following bills filed in Congress constitutional? 1. A bill originating from the Senate, which provides for the creation of the Public Utility Commission to regulate public service companies and appropriating the initial funds needed to establish the same. Explain. 2. A bill creating a joint legislative executive commission to give on behalf of the Senate its advice, consent, and concurrence to treaties entered into by the President. The bill contains the guidelines to be followed by the Commission in the discharge of its functions. Explain. A. 1. A bill providing for the creation of the Public Utility Commission to regulate public service companies and appropriating funds needed to establish it may originate from the Senate. It is not an appropriation bill because the appropriation of public funds is not the principal purpose of the bill. In Association of Small Landowners of the Philippines, Inc., v. Secretary of Agrarian Reform 175, SCRA 343, it was held that a law is not an appropriate measure if the appropriation of public funds is not its principal purpose and the appropriation is only incidental to some other objective. 2. A bill creating a joint legislative executive commission to give, on behalf of the Senate, its advice, consent, and concurrence to treaties entered into by the President. The Senate cannot delegate this function to such a commission because, under Section 21, Article 7 of the Constitution, the concurrence of at least 2/3 of the Senate itself is required for the ratification of treaties. Initiative and referendum. Q. The present Constitution introduced the concepts and processes of initiative and referendum. Compare and differentiate one from the other. A. Initiative is the power of the people to propose amendments to the Constitution or to propose and enact legislations through an election called for the purpose. Referendum is the power of the electorate to approve or reject a legislation through an election called for the purpose. Q. What are the essential elements of a valid petition for a people's initiative to amend the 1987 Constitution? Discuss. A. The elements of a valid petition for a people's initiative are the following. 1. At least 12% of the registered voters, of which every legislative district must be represented by at least 3% of the registered voters in it, should directly sign the entire proposal, and 2. The draft of the proposed amendment must be embodied in the petition. Q. Several citizens, unhappy with the proliferation of families dominating the political landscape, decided to take matters into their own hands. They proposed to come up with a people's initiative defining political dynasties. They started a signature campaign for the purpose of coming up with a petition for that purpose. Some others expressed misgivings about a people's initiative for the purpose of proposing amendments to the Constitution, however. They cited the court's decision in Santiago v. Commission on Elections, 270 SCRA 106, 1997, as authority for their position that there is yet no enabling law for such purpose. On the other hand, there are also those who claim that the individual votes of the justices in Lambino v. Commission on Elections, 505 SCRA 160, 2006, mean that Santiago's pronouncement has effectively been abandoned. If you were consulted by those behind the new attempt at a people's initiative, how would you advise them? A. I shall advise those starting a people's initiative that initiative to pass a law defining political dynasties may proceed as their proposal is to enact a law only, and not to amend the Constitution. The decision in Santiago v. Com-Elec 270 SCRA 106, 1997, which has not been reversed, upheld the adequacy of the provisions in the Republic Act 6735 on initiative to enact a law. Alternative answer. I shall advise those starting a people's initiative that the ruling in Santiago v. Commission on Election that there is as yet no enabling law for an initiative has not been reversed. According to Section 4.3, Article 8 of the Constitution, a doctrine of law laid down in a decision rendered by the Supreme Court in banc may not be reversed, except if it is acting in banc. The majority opinion in Lambino v. Com-Elec 505 SCRA 160, 2006, refused to re-examine the ruling in Santiago v. Com-Elec because it was not necessary for deciding the case. The justices who voted to reverse the ruling constituted the minority. Senate. Q. A few months before the end of the present Congress, Strongwill was invited by the Senate to shed light in an inquiry relative to the alleged siphoning and diverting of the pork barrel of members of Congress to non-existent or fictitious projects. Strongwill has been identified in the news as the principal actor responsible for the scandal, the leader of a non-governmental organization which ostensibly funneled the funds to certain local government projects which existed only on paper. At the start of the hearings before the Senate, Strongwill refused at once to cooperate. The Senate cited him in contempt and sent him to jail until he would have seen the light. The Congress thereafter adjourned sine die preparatory to the assumption to office of the newly elected members. In the meantime, Strongwill languished behind bars, and the remaining senators refused to have him released, claiming that the Senate is a continuing body, and therefore he can be detained indefinitely. Are the senators right? A. The senators are right. The Senate is to be considered as a continuing body of purposes of its exercise of its power punished for contempt. Accordingly, the continuing validity of its orders punishing for contempt should not be affected by its sine die adjournment. Alternative answer. The senators are right. While the Senate as an institution is continuing in the conduct of its day-to-day business, the Senate of each Congress acts separately from the Senate of the Congress before it. All pending matters terminate upon expiration of each Congress. House of Representatives. District Representatives and Questions of Apportionment. Q. With the passage of time, the members of the House of Representatives increased with the creation of new legislative districts and the corresponding adjustments in the number of party list representatives. At a time when the House membership was already 290, a great number of the members decided that it was time to propose amendments to the Constitution. The senators, however, were cool to the idea. But the members of the House insisted. They accordingly convened Congress into a constituent assembly in spite of the opposition of the majority of the members of the Senate. When the votes were counted, 275 members of the House of Representatives approved the proposed amendments. Only 10 senators supported such proposals. The proponents now claim that the proposals were validly made, since more than the required 3/4 vote of Congress has been obtained. The 14 senators who voted against the proposals claim that the proposals needed not 3/4 vote of the entire Congress, but each House. Since the required number of votes in the Senate was not obtained, then there could be no valid proposals, so argued the senators. Were the proposals validly adopted by Congress? A. The proposals were not validly adopted, because the 10 senators who voted in favor of the proposed amendments constituted less than 3/4 of all the members of the Senate. Although Section 1, Article 27 of the Constitution did not expressly provide that the Senate and the House of Representatives must vote separately, when the legislature consists of 2 houses, the determination of one house is to be submitted to the separate determination of the other house. Q. On August 15, 2015, Congresswoman Dina Tatalo filed and sponsored House Bill No. 5432, entitled An Act Providing for the Apportionment of the Lone District of the City of Pangarap. The bill eventually became a law, R.A. No. 1234. It mandated that the lone legislative district of the city of Pangarap would now consist of 2 districts. For the 2016 elections, the voters of the city of Pangarap would be classified as belonging to either the 1st or 2nd district, depending on their place of residence. The constituents of each district would elect their own representative to Congress, as well as 8 members of the Sangguniang Panglungsod. R.A. No. 1234 apportioned the city's barangays. The COMELEC thereafter promulgated the Resolution No. 2170, implementing R.A. No. 1234. Piolo Cruz assails the COMELEC resolution as unconstitutional. According to him, R.A. No. 1234 cannot be implemented without conducting a plebiscite, because the apportionment under the law falls within the meaning of creation, division, merger, abolition, or substantial alteration of boundaries of cities under Section 10, Article 10 of the 1987 Constitution. Is the claim correct? Explain. A. The claim is not correct. The Constitution does not require a plebiscite for the creation of a new legislative district, by a legislative reapportionment. It is required only for the creation of new local government units. Party List System, RA number 7941. Q. The Supreme Court has provided a formula for allocating seats for party list representatives. A. The 20% allocation. The combined number of all party list congressmen shall not exceed 20% of the total membership of the House of Representatives, including those elected under the party list. B. The 2% threshold. Only those parties garnering a minimum of 2% of the total valid votes cast for the party list system are qualified to have a seat in the House of Representatives. C. The 3-seat limit. Each qualified party, regardless of the number of votes it actually obtained, is entitled to a maximum of 3 seats, that is, 1 qualifying and 2 additional seats. For each of these rules, state the constitutional or legal basis, if any, and the purpose. A. The party list congressman should not exceed 20% of the total membership of the House of Representatives, because this is the maximum number of party list congressmen. B. Under Section 11B of Republic Act 7941, only the parties which received at least 2% of the total votes cast for the party list are entitled to have a seat in the House of Representatives. To have meaningful representation, the elected party list representative must have the mandate of a sufficient number of people. C. Section 11B of Republic Act 7941 allows qualified parties to have a maximum of 3 seats in the House of Representatives, so that no single group will dominate the party list seats. D. Additional seats to which a qualified party is entitled are determined by the proportion of the total number of votes obtained by the party with the highest number of votes, to maintain proportional representation. This is because while representation in the party list system is proportional, a party is entitled to a maximum of 3 seats regardless of the number of votes it actually obtained. Q. Greenpeace is an ideology-based political party fighting for environmental causes. It decided to participate under the party list system. When the election results came in, it obtained only 1.99% of the votes cast under the party list system. Blue Bean, a political observer, claimed that Greenpeace is not entitled to any seat since it failed to obtain at least 2% of the votes. Moreover, since it does not represent any of the marginalized and underrepresented sectors of society, Greenpeace is not entitled to participate under the party list system. How valid are the observations of Blue Bean? A. The claim of Blue Bean that Greenpeace is not entitled to a seat under the party list system because it obtained only 1.99% of the votes cast under the party list system is not correct. The provision in Section 5.2, Article 6 of the Constitution provides that the party list representatives shall constitute 20% of the total number of the members of the House of Representatives is mandatory. After the parties receiving at least 2% of the total votes cast for the party list system have been allocated 1 seat, the remaining seats should be allocated among the parties by the proportional percentage of the votes received by each party as against the total party list votes. The claim of Blue Bean that Greenpeace is not entitled to participate in the party list elections because it does not represent any marginalized and underrepresented sectors of society is not correct. It is enough that its principal advocacy pertains to the special interest of its sector. The Partido ng Mapagkakatiwalang Filipino, PMP, is a major political party which has participated in every election since the enactment of the 1987 Constitution. It has fielded candidates mostly for legislative district elections. In fact, a number of its members were elected and are actually serving in the House of Representatives. In the coming 2016 elections, the PMP leadership intends to join the party list system. Can PMP join the party list system without violating the Constitution and Republic Act RA number 7941? A. Yes. As for political parties, they may participate in the party list race by registering under the party list system and no longer field congressional candidates. These parties, if they field congressional candidates, however, are not barred from participating in the party list elections. What they need to do is register their sectoral wing or party under the party list system. This sectoral wing shall be considered an independent sectoral party, linked to a political party through a coalition. Legislative privileges, inhibitions, and disqualifications. Q. State the rule making it incompatible for members of Congress to hold offices or employment in the government. A. Section 13, Article 7 of the Constitution, which prohibits members of Congress from holding any other office during their term without forfeiting their seat, does not distinguish between government corporations with original charters and their subsidiaries, because the prohibition applies to both. Q. Victor Ahmad was born on December 16, 1972, of a Filipino mother and an alien father. Under the law of his father's country, his mother did not acquire his father's citizenship. Victor consults you on December 21, 1993, and informs you of his intention to run for Congress in the 1995 elections. Is he qualified to run? What advice would you give him? Would your answer be the same if he had seen and consulted you on December 16, 1991, and informed you of his desire to run for Congress in the 1992 elections? Discuss your answer. No. Victor Ahmad is not qualified to run for Congress in the 1995 elections. Under Section 6, Article 6 of the Constitution, a member of the House of Representatives must be at least 25 years of age on the day of the election. Since he will be less than 25 years of age in 1995, Victor Ahmad is not qualified to run. Under Section 2, Article 4 of the Constitution, to be deemed a natural-born citizen, Victor Ahmad must elect Philippine citizenship upon reaching the age of majority. I shall advise him to elect Philippine citizenship, if he has not yet done so, and to wait until the 1998 elections. My answer will be the same if he consulted me in 1991 and informed me of his desire to run in the 1992 elections. Alternative answer. Under Section 2, Article 4 of the Constitution, Victor Ahmad must have elected Philippine citizenship upon reaching the age of majority to be considered a natural-born citizen and qualified to run for Congress. Republic Act No. 6809 reduced the majority age to 18 years. Cuenco v. Secretary of Justice 5 SCRA 108 recognized 3 years from reaching the age of majority as the reasonable period for electing Philippine citizenship. Since Republic Act No. 6809 took effect in 1989, and there is no showing that Victor Ahmad elected Philippine citizenship within 3 years from the time he reached the age of majority on December 16, 1990, he is not qualified to run for Congress. If he consulted me on December 16, 1991, I would inform him that he should elect Philippine citizenship so that he can be considered a natural-born citizen. Q. During his third term, A member of the House of Representatives, was suspended from office for a period of 60 days by his colleagues upon a vote of 2/3 of all the members of the House. In the next succeeding election, he filed his certificate of candidacy for the same position. B. The opposing candidate filed an action for disqualification of A on the ground that the latter's candidacy violated Section 7, Article 4 of the Constitution, which provides that no member of the House of Representatives shall serve for more than 3 consecutive terms. A answered that he was not barred from running again for that position because his service was interrupted by his 60-day suspension, which was involuntary. Can A legally continue with his candidacy, or is he already barred? Why? A cannot legally continue with his candidacy. He was elected as a member of the House of Representatives for a 3rd term. This term should be concluded in the computation of the term limits, even if A did not serve for a full term. He remained a member of the House of Representatives even if he was suspended. Q. JAR faces a dilemma. Should he accept a cabinet appointment now or run later for senator? Having succeeded in law practice as well as prospered in private business, where he and his wife have substantial investments, he now contemplates public service, but without losing the flexibility to engage in corporate affairs or participate in professional activities within ethical bounds. Taking into account the prohibitions and inhibitions of political office, whether as senator or secretary, he turns to you for advice to resolve his dilemma. What is your advice? Explain briefly. I shall advise JAR to run for senator. As senator, he can retain his investments in his business, although he must make a full disclosure of his business and financial interests and notify the Senate of a potential conflict of interest if he authors a bill. He can continue practicing law, but he cannot personally appear as counsel before any court of justice, the electoral tribunals, or quasi-judicial and other administrative bodies. As a member of the cabinet, JAR cannot directly or indirectly practice law or participate in any business. He will have to divest himself of his investments in his business. In fact, the constitutional prohibition imposed on members of the cabinet covers both public and private office or employment. Q. A Congresswoman A is a co-owner of an industrial estate in Sta Rosa Laguna, which she has declared in her statement of assets and liabilities. As a member of her political party authored a bill which would provide a 5-year development plan for all industrial estates in southern Tagalog region to attract investors. The plan included an appropriation of 2 billion pesos for construction of roads around the estates. When the bill finally became law, a civil society watchdog questioned the constitutionality of the law as it obviously benefited Congresswoman A's industrial estate. Decide with reasons. A. The law is constitutional. Section 12, Article 6 of the Constitution does not prohibit the enactment of a law which will benefit the business interests of a member of the Senate or the House of Representatives. It only requires that if the member of Congress whose business interests will be benefited by the law is the one who will file the bill, he should notify the House concerned of the potential conflict of interest. Q. In the May 2013 elections, the Allied Workers Group of the Philippines, AWGP, representing land-based and sea-based workers in the Philippines and overseas, won in the party-list congressional elections. Attorney Abling, a labor lawyer, is its nominee. As part of the party's advocacy and services, Congressman Abling engages in labor counseling, particularly for local workers with claims against their employers and for those who need representation in collective bargaining negotiations with employers. When labor cases arise, AWGP enters its appearance in representation of the workers, and the congressman makes it a point to be there to accompany the workers, although a retained counsel also formally enters his appearance and is invariably there. Congressman Abling largely takes a passive role in the proceedings, although he occasionally speaks to supplement the retained counsel's statements. It is otherwise in CBA negotiations where he actively participates. Management lawyers, feeling aggrieved that a congressman should not actively participate before labor tribunals and before employers because of the influence a congressman can wield, filed a disbarment case against the congressman before the Supreme Court for his violation of the Code of Professional Responsibility and for breach of trust, in relation particularly with the prohibitions on legislators under the Constitution. Is the cited ground for disbarment meritorious? A. Being a congressman, Attorney Abling is disqualified under Article 5I, Section 14 of the 1987 Constitution from personally appearing as counsel before quasi-judicial and other administrative bodies. Handling labor cases constitutes personal appearance before them. His involvement in collective bargaining negotiations also involves practice of law because he is making use of his legal knowledge for the benefit of others. The Bureau of Labor Relations is involved in collective bargaining negotiations. Attorney Abling should not be disbarred, but should be merely suspended from the practice of law. Suspension is the appropriate penalty for involvement in the unlawful practice of law. Alternative answer. No, Congressman Abling cannot be disbarred. A retained counsel formally appears for AWGP. His role is largely passive and cannot be considered as personal appearance. His participation in the collective bargaining negotiations does not entail personal appearance before an administrative body. Discipline of members. Q. Simeon Valera was formerly a provincial governor who ran and won as a member of the House of Representatives for the 2nd Congressional District of Iloilo. For violation of Section 3 of the Anti-Graft and Corrupt Practices Act, RA number 3019, as amended, allegedly committed when he was still a provincial governor. A criminal complaint was filed against him before the office of the Ombudsman, for which, upon a finding of probable cause, a criminal case was filed with the Sandiganbayan. During the course of trial, the Sandiganbayan issued an order of preventative suspension for 90 days against him. Representative Valera questioned the validity of the Sandiganbayan order on the ground that under Article 6, Section 16(3) of the Constitution, he can be suspended only by the House of Representatives, and that the criminal case against him did not arise from his actuations as a member of the House of Representatives. Is Representative Valera's contention correct? Why? A. The contention of Representative Valera is not correct, as held in Santiago v. Sandiganbayan, 356, SCRA 636. The suspension contemplated in Article 6, Section 16(3) of the Constitution is a punishment that is imposed by the Senate or House of Representatives upon an erring member. It is distinct from the suspension under Section 13 of the Anti-Graft and Corrupt Practices Act, which is not a penalty but a preventative measure. Since Section 13 of the Anti-Graft and Corruption Practices Act does not state that the public officer must be suspended only in the office where he is alleged to have committed the acts which he has been charged, it applies to any office which he may be holding. Q. In an election case, the House of Representatives Electoral Tribunal rendered a decision upholding the election protest of Protestant A, a member of the Freedom Party, against Protestee B, a member of the Federal Party. The deciding vote in favor of A was cast by Representative X, a member of the Federal Party. For having voted against his party mate, Representative X was removed by resolution of the House of Representatives, at the insistence of his party, the Federal Party, from membership in the HRET. Representative X protested his removal on the ground that he voted on the basis of the evidence presented, and contended that he had security of tenure as a HRET member, and that he cannot be removed except for a valid cause. With whose contention do you agree? That of the Federal Party, or that of Representative X? Why? A. I agree with the contention of Representative X, as held in Bondoc v. Pineda, 201 SCRA 792. The members of the House of Representatives Electoral Tribunal are entitled to security of tenure like members of the judiciary. Membership in it may not be terminated except for a just cause. Disloyalty to party is not a valid ground for the expulsion of a member of the House of Representatives Electoral Tribunal. Its members must discharge their functions with impartiality and independence from the political party to which they belong. Q. AVE ran for Congressman of QU Province. However, his opponent, BART, was the one proclaimed and seated as the winner of the election by the COMELEC. AVE filed seasonably a protest before the HRET, House of Representatives Electoral Tribunal. After 2 years, HRET reversed the COMELEC's decision, and AVE was proclaimed finally as the duly elected congressman. Thus, he had only 1 year to serve in Congress. Can AVE collect salaries and allowances from the government for the first 2 years of his term as congressman? Should BART refund to the government the salaries and allowances he had received as congressman? What will happen to the bills that BART alone authored and were approved by the House of Representatives while he was seated as congressman? Reason and explain briefly. A. AVE cannot collect salaries and allowances from the government for the first 2 years of his term, because in the meanwhile, BART collected the salaries and allowances. BART was the de facto officer while he was in possession of the office. To allow AVE to collect the salaries and allowances will result in making the government pay a second time. BART is not required to refund the government the salaries and allowances he received. As the de facto officer, he is entitled to the salaries and allowances because he rendered services during his incumbency. The bills which BART alone authored and were approved by the House of Representatives are valid because he was a de facto officer during his incumbency. The acts of a de facto officer are valid insofar as the public is concerned. The Philippine Constitution. Constitution. Definition: